Good evening, everyone, and welcome to tonight's live webinar with Doris Bonora. Just a couple housekeeping items. Please note that everyone will be muted for the presentation. If you would like to ask questions, please type into the chat box at the bottom right-hand portion of your screen. As well, I would like to remind everyone that we are still open, although working remotely. All offices across the province are open and available to support you, so please feel free to reach out if you need our services right now. So right now, people living with dementia need support more than ever. These are challenging times and the needs are great. Our services are free of charge, and we're asking that if you're able to help more families receive the support they need, to please donate. There will be an opportunity at the end of this presentation if you so choose, and thank you for your continued support. I'd now like to take a moment to introduce our speaker for the evening. Doris has been in practice for over 30 years in the area of will planning, estate, tax planning, estate administration, and trusts. Doris also practiced in the area of estate litigation. She has been involved in estate litigation involving farms, support claims for spouses, support claims for dependent children, challenges to capacity to make a will, and all litigation involving estate administration issues. Doris has also been involved in the litigation involving financial elder abuse and abuse under enduring power of attorney. Doris's practice has had her represent individuals in multi-million-dollar trusts, First Nation trusts, and Métis settlements. She has helped many people from many different cultures and many different orientations to achieve their estate planning goals. Finally, Doris has acted for clients who need to make application for an appointment for guardians and trustees. She has appeared at all levels of the court in Alberta to litigate various estate issues. And thank you for being here tonight, Doris, and welcome. And I will pass the floor over to you.
Thank you very much. Probably the thing that's missing from my resume that I'm very proud of is my association with the Alzheimer's Society. So I'm going to have to spruce up that bio. I sat on the local board in Edmonton and also was on the provincial board. And I love the work that I did there, but my favorite work was working with families. And so after I served a term on the board, I have continued doing presentations for families who are on this Alzheimer's journey and trying to help them in any ways we can from a legal perspective. And so we have so enjoyed being part of the Seeds of Hope program and offering our knowledge, and certainly the staff at the Alzheimer's Society refer people to me when they have a simple question that they need answered, and that makes me very happy that I can help in some small way. Feel free to enter your questions on this chat room. I always think it's great to be able to answer questions as we go, and I think it's hard to remember questions at the end and then they're kind of out of context. So please feel free to enter them. Please know that it's, not easy to get free legal advice. So take advantage tonight of this opportunity with me. So hopefully I can answer the questions that you have. Tonight's going to be a bit more of a general presentation around estate planning. I'm going to work in some of the more particular things for when a family has someone who has the person in their family who has the Alzheimer's disease, or some kind of dementia. But mostly it's going to be general estate planning because, of course, that affects everyone. Everyone can get sick. Everyone is going to die at some point. Hopefully that's not a surprise to any of you. And of course, in this pandemic, we've been very busy because people have been thinking about illness and death. So tonight, if you thought it was going to be a light topic, unfortunately, we are going to talk about illness and death in case you wanted to switch the channel before we moved on. Hopefully you won't. Okay, I just need to find. So the big, I'm just trying to switch this. There we go. So a big part of what we want to talk about tonight is the importance of planning ahead. I think lots of people think, oh, getting a will done might be expensive and they don't want to spend that money right now. And certainly, if you have someone in your family who's lost a job, that may be very difficult. But without that planning, I can assure you that it gets very much more expensive after you die if you haven't done that planning. And so really the discussion tonight is all about how can we plan in the event that we become ill and how can we plan after death? Because we really think that you don't want to be the kind of family that's fighting. You kind of want to be this happy family. And really what we see in our practice is when people end up in court after someone has died because there wasn't good planning, you really end up being that unhappy family, perhaps forever. And so we like to say that, the goal of any good will is to make sure that your family is going to get together the year after you die for Christmas, because they're still happy because you did that planning and they didn't have big battles after you die. And we certainly have noticed too that people can have those same big battles even when somebody just becomes ill and now can't participate in their decisions. We'll talk a bit about that. So I think without planning, you can perhaps prepare to be a victim. So when I'm doing these talks, I will or spruce up your will. But actually, this talk, you should maybe kind of spread out to the rest of your family, because if you die without a will, it actually doesn't impact you very much. Hopefully you're going to some better place. You'll be looking down at the mess you created. So it's actually more important for you to make sure that your husband, your mom, your aunt, your children all have their wills done. Otherwise, part of your retirement would be spent cleaning up other people's messes. So important to have one for you, absolutely, but also important to think about the other people in your family who can make your life miserable because they didn't do a will. Certainly costs increase, and more of your estate will be spent for legal and accounting fees and taxes if there isn't proper planning. But more importantly, we love our families. We always want to take care of them. That's been hard in this pandemic where, we can't see our families as we would like. And so a little bit of planning at the front end can make their lives very good. And generally, most of us want that. We spend a lot of time building up money. Wouldn't it make sense to kind of plan for that after you're gone, rather than just saying, oh, I'm sure they'll work it out, because I'm pretty confident they won't. I can tell you that in our practice, we certainly find the more lucrative part of practice is estate litigation. So where families are in a dispute in some way is where lawyers make more money. It's not really at the front end where the planning is done. So if you think about this, what if tomorrow your spouse or partner was in a serious accident, or someone close to you? And can you answer these questions? Like, who would pay their mortgage? Who would apply for their disability insurance? Who would pay utilities and taxes? Lots of people who are married or have a partner would say, well, we just, continue to pay the mortgage from our joint account. But then, and probably maybe that's the same answer for utilities and taxes, but can you apply for their disability insurance? Because there's a lot of privacy laws. And when you go and say to the disability insurer, say my husband's in the hospital and we need to apply for his disability insurance, so can you tell me how to go about doing that? The disability insurer may say, I'm not telling you anything because that's his private information. So first prove to me that you have the right to get that information. So the question is, what authority do you have to get that information, even just from the disability insurer or from doctors and nurses? How will you access really basic information? And the answer really to that question is that you want to have an enduring power of attorney. And everyone should have these. Should have an enduring power of attorney that deals with financial matters, so that If your partner was in the hospital, you could immediately step in, produce your document, and the disability insurer is going to talk to you. You can go to the bank, you can go to the utility companies, you can do all of those things. At the Alzheimer's Society, we often hear from people who say, you know, my mom seems to be hiding her mail. I don't know if her utilities are paid. I tried calling TELUS just to say, hey, is my mom's bill paid? If not, I'll pay it. And TELUS will say, I'm not telling you anything. And so even simple things like figuring out utility issues are not going to be dealt with, because the utility companies and the government and the banks are all going to say, no, our primary concern is protecting someone's privacy, which of course we all want. But when somebody's sick and you want to help them, now privacy becomes this big brick wall that you run into. And the way to get over the brick wall is to have an enduring power of attorney. They can be springing or immediate, so they'll come into effect immediately if you want them to. And if somebody has an early diagnosis of Alzheimer's disease or dementia, we would say do an immediate power of attorney so that you can appoint your family to help you as you need it. So initially, not a lot of help needed. As things progress through the disease and the person needs a bit more help, or they start to spend too much money, someone who's appointed under a power of attorney can now just go behind the scenes and fix it. So if they're spending too much on their credit card, you can put a lower limit on the credit card. If they still want to write checks every once in a while, you can leave money in their checking account. So we're very big, I say we at the Alzheimer's Society, but me as a person feel very strongly that as people age and as perhaps they get dementia, that we give them dignity for as long as possible. And so if you sign an immediate power of attorney at the beginning, you never have to declare them incapacitated. You can just help them as you need to, giving them as much dignity as possible without ever saying, oh, sorry, you can't use your credit card anymore, you can't go to the bank, which takes away all of those joys that maybe somebody has, but certainly takes away, again, more of their dignity. With a springing power of attorney, it's going to say it comes into effect when you're declared incapacitated. So if you are healthy now and you have no diseases at all, you probably want a springing power of attorney. And then it will come into effect if you're declared incapacitated. With dementia, testing is not fun for anyone. And so what we find is that sometimes people have been doing things at home where they need assistance, or spending too much money, or hiding their bills, hiding money. And then you take your mom to the doctor to say, okay, all these things are happening. And then your mom is perfect at the doctor, and the doctor thinks you have the problem. And so then you can't get her declared incapacitated because she hasn't acted incapacitated at the doctor's, and now you're back into a period of not being able to help her. So even if you had a power of attorney in place at the time you were diagnosed, we would recommend changing it to make it immediate. Who you appoint in your power of attorney is the most important decision you'll make. When these documents came into effect in the late 1980s, we were so excited because now you could, without going to court, appoint someone to manage your financial affairs. And we just thought it was a really great thing, a nice little private system where you got to choose the person, easy to put in place. What we didn't realize is, of course, they would be an easy target for fraud. And so what we see is that a lot of people, unfortunately, abuse their relatives by getting a power of attorney and then deciding to use the money in their accounts for their own purposes. Very, very sad. You know, I've seen the son who says, oh, but, you know, I have to run errands for my mom and I just needed a new Toyota Camry to do that. And that's obviously not a very good thing. And so, as was said in my bio, I deal with a lot of financial abuse of seniors and trying to collect that money back and deal with it. But more importantly, to have prevention. So if you have a spouse, you would probably appoint them in your power of attorney. But let's be clear about that. If your spouse has now been diagnosed with Alzheimer's and you've had a power of attorney in place that named him, maybe you would want to change that now. But other than your spouse, once you're looking at your plan B, and every document should have a plan B. You and your spouse travel in the same car. If you're both in the same accident and you've only named each other in your document, now you have nobody to be your power of attorney. So in your plan B, you have to think about, who are those people who I should appoint? And I think the best way to have prevention is to say that there would be 2 people appointed so they can oversee each other, and so then there wouldn't be abuse. I often get asked, can I appoint all of my children? And the answer is yes. And it's okay if one of them lives in Calgary and the other one lives in Fort McMurray, because there's lots of ways to communicate, as we have learned in this pandemic. And most banking is done electronically, so it's pretty easy to manage a power of attorney, even though people live far away. So think more about what's the right skill set, who's the person who has time to do this, who can make sure your bills are paid, your investments are invested, and who would make good decisions for your care. In the power of attorney, we definitely want to say that if you support someone, if you support your spouse, or you support your children, even if they're adults. Of course, children seem to stick around longer even after they're adults. If you want to support your children while they're in post-secondary, or you want to support grandchildren while they're going to university, you need to say this in your power of attorney, because your power of attorney, the attorney appointed under your power of attorney, should only use your money for you. And if he wants to use money for anything else, that can't happen. So if you expect your money to be used for any other purpose, it needs to say that. And so we have lots of people who support families in other countries. If you want that to continue, your power of attorney needs to say that. If you would want money to continue to go to a charity, if you gave regularly to the Alzheimer's Society or regularly to your church, and you wanted that to continue even if you became incapacitated, you would need to say that in your document. So while these powers of attorney generally look a lot alike for most people, you should make sure that your power of attorney really matches you. We often want to make reference to things that are in the will. So I have, sell land or restrict the sale of land. So if you're not going to live in your house anymore, we probably want the ability to sell it, because it's hard to keep an empty house. But maybe you have a cottage or a piece of farmland that has been passed down in your family and should stay in your family. Or maybe the cottage just has, everybody has so much fun there that you would not want it sold just because you became incapacitated, especially because we could be talking about a stroke where you'll recover from it. And so in that case, you might say, don't sell my recreational property, let my kids use it until I die, and then my will take over. We had a case once where this woman appointed her accountant as her attorney. She thought, well, he's good with doing my taxes and my financial statements, so he would be good at managing my money. And he was at that part. The one thing, though, is he didn't know her very well, and he didn't know that she was an artist. And in her will, she had actually said that all of these pieces of art that she had created were supposed to go to specific members of her family. Well, when she became ill and needed to go to a nursing home, he didn't read her will. And nothing in the power of attorney told him he should do anything different. So he had a big garage sale. And so all of her art just got sold. And so, of course, when she died and we read the will, none of that art existed anymore. So a very sad result, in the sense that her legacy just was never protected. And all of the family who wanted a piece of her legacy from art were not satisfied. So it's important that if there are things you want to have happen in your will, that you make reference to it in the enduring power of attorney, because otherwise things can happen when you're incapacitated that might wreck your wishes in your will. I'm just going to look and make sure I don't have any questions. So the question was, what's the difference between springing and enduring? So springing is that it comes into effect in the future. So it's not coming into effect now. And enduring is that it will stay in effect even when you're incapacitated. And so in the springing when it comes into effect when you're incapacitated, and it will just stay in effect. So we've had powers of attorney since the Crusades. So when, someone went off to go to the new land to discover tobacco or spices, he would leave an attorney, a power of attorney in place, like with a brother, to manage his lands and his family and all of those things. But those powers of attorney, until the enduring power of attorney came along, were only in effect as long as that person had capacity. So as soon as the person lost capacity, the power of attorney was no longer valid. So the enduring part of this is that it stays in effect even though the person who gave it doesn't have capacity anymore. The next question is, can the power of attorney expire? And the answer is no. You do a power of attorney, and as long as you signed it properly, it will never expire. That's not to say that you shouldn't look at it every once in a while, because of course things can change. Maybe the person you appointed when you did your power of attorney was a great guy, but now he's developed a gambling addiction. Pretty bad idea to name somebody who has a gambling addiction and put them in charge of your money. You will wake up from the coma with no money. So it's important to review these and make sure they're still appropriate for you, especially with respect to the people you've appointed. The next question is, if the life insurance is to be handled by an attorney, that should be specifically stated in the power of attorney. If not, the default is that it does not. So I think that sounds like a statement. In terms of dealing with the insurance, the idea would be the payment of premiums should continue. You might say that your insurance should not be canceled. The one thing an enduring power of attorney cannot do is change the beneficiaries in that life insurance policy or even name beneficiaries. Whoever is named as a beneficiary at that time that you become incapacity until you regain capacity cannot be changed. Okay, I'm going to go on to talking about personal directives, but if you have questions about powers of attorney later, please don't hesitate to ask those. So the personal directive is really just the flip side of the enduring power of attorney. So if you're sick and you need someone to manage your finances, then you also need someone to manage your health care. And here you're appointing an agent, that's what they're called in the personal directive, to manage your health care or personal matters. This document only takes effect on mental incapacity. As long as you have capacity, doctors want you involved in your own care. And so they will involve you. And they might involve you a lot or a little. So maybe you only have capacity to decide what you want for lunch today. They'll let you decide that. If you can't maybe have the capacity to decide whether you should have some complicated surgery, then they'll go to your agent to decide that. So it's kind of operates a bit more on a continuum in terms of how involved you are. In terms of who you should appoint here, you really need to think about who are the people who will make decisions like you would make them. You need to think about who will be that great healthcare advocate for you. If you've been involved in the healthcare system, you know that the only way you get good care is by being a good advocate, either for yourself or someone else that you're taking care of. If you're not a strong advocate, you're the best person for the healthcare system because you're not making any noise and they don't have to pay attention to you. And I'm not suggesting that they're going to neglect you, but if somebody's crying and making a lot of noise about getting the test today, then the person who's saying nothing might get bumped. And so when you're thinking about who your agent is, think about the person who will say, hey, she was supposed to have those tests today. How come that didn't happen? Or, hey, since she's come to this nursing home, I feel like she's a lot dopier than she was before. Like, should we do a review of the medications? You want somebody who can come and visit because you can make a lot of decisions, of course, remotely. And of course, during this COVID time, we have not been able to visit our relatives in nursing homes. But generally, we would want someone to come and visit us and observe what is happening in the facility that you're in. So think carefully about who that is. Again, if you say, look, I have 3 children and one lives here, one lives in Calgary, one lives in Fort McMurray, can we appoint all of them? Usually, actually, the answer I get is, so I'm just going to appoint the one that's here because that makes sense. They'll be around. And I say, well, listen, let's think about that. Do your children get along? Answer, yes. Okay, well, if your children get along, then I would appoint all 3 of them, because then the one that's in Fort McMurray and the one that's in Calgary can call the doctor directly and find out what's going on, can call the nurse's station and ask about you. If, in fact, they're not appointed, then they have to have their information filtered through the one you've appointed. But the big caveat on that was, do they get along? Because if they don't, they're not going to get along better just because you've appointed them in the personal directive. So think about that. Think carefully about who's your best healthcare advocate. Your personal directive can provide lots of details. There's lots of people who never want to go to a nursing home. They just want to be taken care of in their own home. And certainly you can put that in as a detail. Usually we would say, but understand that your home, like you may become too sick to be cared for in your own home. This is the place. We used to call this document a living will, or some people call it a healthcare directive. Some people call it the pull the plug document. So this is the place where you can say, if I'm in a vegetative state with no known hope of recovery, then I don't want to have interventions. Or if interventions have already been given to me, then I want to be taken off interventions. So you can tell your family how you feel about being kept alive for a long time. And, I've had people who say, no, I want all interventions for as long as possible. I want to live as long as possible. And that's okay too, right? There's no judgment about that. If that's how you feel, then that's what your document should say. I've had families who are a little worried that their families are going to take them off life support a little too soon. So they say, I have to be in the coma for like 30 days or 60 days before they can be taken off life support. So all of these details can go into your document. And certainly I've had people who've said, you know what, I just don't know, and I'm going to leave it up to my family. And you can do that. I just think it's better if you give your family some instructions. And then during this COVID time, we've said, hey, families are isolated. This is the perfect time to talk about this. Perfect time to say, if I had this terrible accident and I was in a coma and I was not going to recover, please don't keep me alive forever. That is not how I want you to remember me. That's not how I want to live. So that you can have that discussion so your family knows what you really want. The other thing you can put in this document is donating organs for transplant purposes. Of course, there's a great need for organs for transplant. Lots of people say to me, I think I'm too old. I think my organs have been well used and nobody wants them. But the transplant teams have told me to say nobody is too old. Our oldest donor in Alberta was 89 years old. So you're never too old, and our bodies now are quite recyclable. So in fact, it's not just about organs, but tissue and bone are all available and potentially useful. So you can say in your document that you'd like all of your organs or body parts, tissue, bone, whatever, donated for transplant, or maybe you want to leave some parts out. So some people say, I don't want my eyes donated, or I don't want my skin on my face donated. Whatever you think is important to you, you can put in this document. So again, this document, just like the power of attorney, should really match you in terms of the kinds of care that you want. And some people add a schedule that says other things that are important to them. So, we've talked about weighty decisions like being taken off life support. But, I had a woman who told me that she visited her friends in nursing homes and they looked terrible. They had bad bedhead and bad nails, and like all of us during this COVID pandemic. And she said, no matter how crazy, her words, crazy she got, she wanted her hair and nails done once a week. And in fact, I know that happened for her. So again, this document can really match you in terms of the kinds of care that you want. So it'll kind of speak for you. I'm going to move on unless there's any questions about personal directives. You can think about your questions while I talk about the alternatives to enduring powers of attorney and personal directives. So before we had enduring powers of attorney and personal directives, the only alternative we had was going to court under the Adult Guardianship and Trusteeship Act. And so you can have a trustee or guardian appointed. The guardian is similar to an agent in a personal directive. The trustee is similar to your attorney under your enduring power of attorney. And under this act, you can have kind of a transitional period where you have a supported decision maker where somebody's helping you decide, or a co-decision maker, or a full guardian and trustee if you've lost capacity. The problem with this system is that there's definitely increased cost. The initial application will likely cost you, it says the range is between $1,000 and $2,500. It's probably closer to $2,500. And the medical report, because it's quite extensive, is between $500 and $700. An enduring power of attorney and personal directive will probably cost you about $250. So you can see right away, you're spending 10 times the amount if you don't have your planning in place. The public guardian interviews the person who is having an application made to have a guardian and trustee appointed. And that maybe doesn't sound like a bad thing, but I can tell you, if the person has dementia, and if they are kind of fighting the disease and thinking that they don't have dementia, and other people think they do, but they don't, and they are worried that maybe they become somewhat paranoid, and then the public guardian comes to their house and says, your daughter thinks you are incapacitated. She has a doctor's report that says that, and she wants to take over your affairs. Do you understand that? How do you feel about that? That might make the person instantly dislike the daughter, even though the daughter has her best interests at heart and the daughter is taking care of the mom. That might ruin that relationship just because that interview has to happen. And we've definitely seen that in our practice. So it's very unfortunate that the person who loves the mom the most, wants to take care of her, now suddenly can't even visit because the mom is so mad at the daughter. And sometimes, you know, even people with dementia have certain things they never forget, and they often don't forget that hate for the daughter, which is very unfortunate. There is potentially a need to account. So after a few years, the court might make you come back and prove as the trustee where you have spent money. And again, that accounting can cost a similar amount of $1,000 to $2,500 in legal fees. And you might need to hire an accountant, which might make it even more expensive. But I think the one or two things that are important about this is that, first of all, you have no control over the appointment. So we've just talked about how important it is to choose someone that's a good attorney for you, someone who's a good agent for you. And here you haven't chosen the person. So who knows who's going to step up to the plate to make decisions for you. It might be someone that you don't actually want to make decisions for you, but now you don't have any more control. Secondly, once you're in the court system, all of your affairs are public. Under a power of attorney and a personal directive, those are never in the court system unless, you know, there's a family dispute over them. But otherwise, they're a completely private system. Whereas here, all of your finances are filed on the courthouse file. All of your medical information is filed on the courthouse file. And anyone can go to the courthouse and look at it because that's a completely public system. So most of us value our privacy. And for sure, one of the ways to protect your privacy is to have an enduring power of attorney and personal directive so your family's never in this court system. Just before I move to talking about wills, I'm just going to make sure there's no questions. Okay, so don't hesitate to ask as we go. So let's talk about wills and what happens after death. I certainly get asked the question, you know, do you think I really need a will? Because I think I mostly just have debt and I don't think anybody wants it. But I would say that the most important reason for having a will is to put somebody in charge. So you appoint an executor. In Alberta, we're now starting to call them personal representatives. You appoint that person who is going to be in charge from the moment that you die, because an executor does have authority to plan the funeral. We say they have dominion over the body, so they can plan the funeral. And without that person, there are no rules, right? So if somebody wants to just go raid the jewelry box, who's stopping them? If they want to decide how the funeral is going to be planned, and there's a dispute about that, well, of course, there might be a problem. But if you have an executor appointed, now the funeral home will just follow that executor. And, don't think for a minute that there aren't huge fights that happen over funerals. I've had a lot of family fights over funerals, and it's so sad. It happens in dysfunctional families. It certainly happens in families where there's a second marriage, and the kids from the first marriage, like to refer to their stepmother as the witch. In those circumstances, they don't always agree on what should happen. So now that if you have an executor, now we know what's going to happen. I think when you don't have an executor, it's kind of like trying to play like some complicated game like football without a referee. And we know that wouldn't work very well. Secondly, you're going to say what the plan is. What is the plan for how you're going to distribute money? Are you just going to give it away? Should we put it in trust? Are there special people you want to give money to? Grandchildren? What are you going to do with your wedding ring? That's the plan you want to put in place for your family, so they don't have to guess and they don't have to have a fight about it. And then finally, so important that, with good planning, you're going to keep your family free from conflict and, more importantly, out of court, so that they don't have a lot of problems. The question is, what happens if no one is appointed as the executor? So you could have a will where no one is appointed as the executor, or maybe you don't have a will at all. Then you have to go to court and have one appointed. And the Surrogate Rules and the Administration of Estates Act sets out who has the first right to apply. So if there's no will, it basically starts with a spouse, and that includes a common law spouse in Alberta, which is someone who lives together for 3 years or more. Children, grandchildren, great-grandchildren, we kind of exhaust that family. And then it would move to parents and then siblings. And it just keeps going down the line. Ultimately, creditors could make a claim to be the executor. And if nobody is around to do it, there's no family whatsoever, then the government would step in to be the executor and run your estate. If there's a will but no executor named, maybe the executor has died, or we find that people who write out their own wills kind of forget to name an executor. In that case, then the list is slightly different in the sense that, yes, we always start with spouse and children, but beneficiaries have a big role to play. So they would be near the top of the list. So if there are people who are supposed to get gifts in the will, they would be appointed before, parents and brothers and sisters and all of that. But that's who would apply. But the problem is, of course, you don't have someone right away. You have to make a court application to appoint that person. So there's no one with automatic rights to be the executor or administrator. So let's talk about the importance of having a will by starting to talk about the kinds of wills that you can have. So in Alberta, you can have a formal will. That will is going to be typewritten or written out in some way, and it's going to be signed, and it'll have 2 witnesses. A holograph will is a will that's entirely in your own handwriting. So you're going to write out what you want. You're going to call it a will so everyone knows that this is supposed to take effect on death, or you're going to say, when I die, here's what I want to have happen. You'll say what's supposed to be distributed and how. Hopefully you'll appoint an executor, and then you sign it and date it. And that is a perfectly valid will in Alberta and in most provinces in Canada, not everywhere in the world. But the most famous holograph will happened in Saskatchewan. So there was a farmer in the 1950s who was dying under his tractor, and he wrote on the bumper, "All to my wife, Mel," and signed it. And that bumper was in court as an exhibit, and now sits at the University of Saskatchewan as the most famous valid holograph will. But my view is that that's the only time you should do a holograph will is when you're dying under a tractor, because holograph wills just are trouble. Generally, some people get them right, but for the most part, people write things that we don't understand after you die. And I'm guessing most people don't write weird things thinking, hey, I'm going to write this and see how much fun they have with that. They write things assuming we're going to understand it, but we don't. And then you have to remember that whenever we're reading a will, the best witness in terms of what that will says is always dead. So a dead witness is not very good for us in court. And so now we have a holograph will, but now we need to interpret it. So I'll give you some examples. We had one person who wrote that a sentence that said, make sure you give something to the little ones. So she probably thought, oh, everyone will know that I want to give $100 to my grandchildren. Had she said that, easy enough, but she didn't say that. And then she had a lot of money. So then there were a whole bunch of people who said, oh, I'm a little one and I want something. So then we had to go to court and solve that. Another example, a woman wrote that she wanted to leave $10,000 to cancer research, which is lovely. But you can't write a check to cancer research. You have to write a check to, the Canadian Cancer Society or the Alberta Cancer Foundation. And so then we had to go to court to figure out where that money should go. And a good result, $10,000 still went to the two organizations she'd given to in the past. The bad result is that we spent legal fees to sort that out. Had she been at a lawyer's office, the lawyer would have said, it's great that you want to leave $10,000 to cancer research. Who should we give it to? And they would have picked an organization, and that would have been the end of that problem. So it's really important wills are just not something that are easy to draft. And again, we have to interpret them, and they mean a lot of money. If people have insurance and a house and, some RIF or some RSP money, it's pretty easy with housing in Edmonton to get to $500,000 or more. And then it's easy to fight. But I would say that people fight about nothing. A little bit of money, a lot of money, they'll fight. And if there's something that is in the will that's ambiguous or difficult to understand, then of course there'll be a battle. And that's not what you want. That's not where you want. I'm confident you have not saved your money to spend it on lawyers after you die. I'm happy to take it from you, but I assure you, I'm sure you're not planning that. And so then I would say, the best way to prevent that is just to have a properly drafted will. Wills can be challenged if there's a proof of contrary intention. So we discourage you from doing a will and then doing lots of little notes about how you want to change your will, or maybe you wanted to add this person. Because if we find those notes, then that could also lead to a problem in terms of a challenge to your will. And then another important consideration for people is what passes under a will and what doesn't. So I think there's lots of people who think, okay, my will is my will. It's going to determine where everything I have goes. But in fact, that's not the case, because there are things that pass what we say outside of the estate. So easy example, if you and your husband own a house together and you're registered on title as joint owners, then when the first person dies, the survivor gets the house. Doesn't matter what the will says, because that joint house with a right of survivorship automatically goes to the survivor. So it's important to make sure you know what are those accounts that you have that are joint. Houses, usually we don't put joint names on, but people like to put joint names on bank accounts. So you're a snowbird and you're going to Palm Desert for the winter. And it's easy if you put your daughter's name on a bank account so that she can pay your bills. But then you die in Palm Desert. And now the daughter says, oh no, that's a joint account, so I'm taking the money because that's what mom wanted. And then, her brothers are going to fight with her. And two cases went to the Supreme Court of Canada a few years ago where same facts, a daughter and a father had joint accounts. And the question was it true joint account where it went to the daughter, or was it not a true joint account and it went to the estate? And the court decided each case differently. So you know that it's very factual. So it's just better not to have joint accounts except with your spouse or partner. But The other thing, every day, sounds like someone on who's listening also knows about life insurance, so maybe they can comment on this too. Every day I see people and I ask them, who are the beneficiaries of your life insurance or the beneficiaries of your RSP or RIF or pensions or your tax-free savings account? And I often get a blank stare. And that is bad, because the beneficiaries on each of these investments is in fact your whole estate plan. So what does your will say? And then what do these beneficiaries say? And you need to keep these up to date. So we see people who start work, they sign up for the group benefits, they're not married, they name their mom as their beneficiary on their group life insurance at work. Now it's 10 years later, they're married, they have 3 kids, and they still have their mom listed as the beneficiary on their life insurance. You need to definitely keep those things up to date. And so if you're on this call and you don't know the answers to those questions, please call tomorrow to your banker, your investment advisor, your human resources person, and find out who you've named and whether those are up to date. Important that you know that RSPs and pensions attract a tax on death. So life insurance is tax-free on death. Tax-free savings account by their very nature are tax-free on death, but not RSPs and pensions. So if you give your RSP to someone, know that your estate will pay the tax, and that can result in some bad things. So if I say this, I have 2 nephews and I have 100,000 in my RSP and I have 100,000 in a bank account, and I say, I'm going to make this equal. I'm going to give my one nephew, Sam, my RSP money, and I'm going to give my other nephew, Tom, my estate. Guess who's going to be the happier guy? Well, it's going to be Sam who's getting the RSP money, because he gets 100,000. And it's going to be Tom who has to pay the tax on the RSP. So he's going to get a lot less. So you can't just willy-nilly put beneficiaries on. You have to know what those consequences are. Otherwise, you might end up with a very unfair result. And we've certainly had estates where, because of the tax on RSPs and pensions, the estate ended up being insolvent and having no money in it. So those beneficiaries who were supposed to get something ended up getting nothing. I think there's a question. Who makes the decisions about item allocation when the will says divide equally and is not specified? Do you mean, it's hard to ask the question back, but if you're asking the question about, what if you divide equally all of my jewelry or divide equally all of my furniture, that is a very hard thing. We don't generally recommend that you try and divide stuff in your house equally, because it's very difficult to do, and it's also very difficult to get things appraised. So easy to get jewelry appraised, but also expensive. So if you have really expensive jewelry, that's okay. But if you have a lot of costume jewelry and now we have to go get that appraised, or if you have coins or stamps, those things often cost between $50 and $75 an hour to get those things appraised. Sometimes the appraisals exceed the value of the items. So we don't generally recommend that. The other issue is that jewelry is very difficult to appraise because there's 2 very different kinds of appraisals for jewelry. So if I'm getting a jewelry appraisal for insurance purposes, so if somebody steals my ring from my house and now I'm going to make a claim on insurance, the insurance company needs to replace that ring. They need to find that diamond, that gold, and they need to have it made. And so that appraisal is going to be pretty high. But if we're talking about an appraisal to sell now my used wedding ring after I die, that's not the same appraisal. That appraisal is, who wants to buy my used wedding ring? And that is often a third or 25% of the value. So it's really difficult to do this. You can, if that's how you choose to do it, you make your executor's life pretty miserable trying to find appraisals for used couches and rocking chairs and things like that. So it says, just to clarify here, does the beneficiary of the RSP pay the tax? No, it's your estate that pays the tax. If the estate did not have enough money to pay the tax, then Revenue Canada may go after the beneficiary. They have the authority to do that and generally will. But the person who is responsible for the payment of tax when your RSP is cashed in when you die is your estate. The only person who can get your RSP without paying tax when you die is your spouse or your partner. Otherwise, there's no other way to save the tax on that. At some point, the government wants their pound of flesh. And so when you die, unless it's going to a spouse, the RSP is taxable. So let's talk about the basic components of a will. The first person I've talked about, most important, choosing an executor. When you're looking at the qualities of that executor, it should be somebody who is diplomatic, somebody who can get things done, not somebody who is the procrastinator, and somebody who you trust to take care of your affairs. So don't pick the person who starts fights, because that's not a good executor. We're going to talk about trusts in a second. So usually your executor is also going to be the trustee of trusts you create. In your will, you would name a guardian for children who are under the age of 18. So anyone who's under the age of 18, if both parents have died, then you can say who you want to have be the guardian. You just have to be careful in this world where everybody lives everywhere, because it's not easy to get a child into another country necessarily. Very difficult, in fact, to get a child to go and live with a guardian in the US unless you can prove the child has independent resources to pay for private school and private medical attention. So you should check out the guardian, not just in terms of whether he or she is a good choice for raising your child, but also in terms of whether they can actually go to the country where your guardian is. I like to talk about trust because I think lots of people don't do their wills because they don't know the answers to the problems they see in their family. And I would say that, first of all, you shouldn't necessarily need to know the answers. I probably have drafted a few more wills than you. And so I probably know some of the answers to your questions, or at least have some options for you. So I would say go to the lawyer with your goals. Don't go thinking, or don't procrastinate going because you don't know the answers. You may get different answers when you go there when a lawyer gives you advice. So I would just say, if you know your goal is to give it to your children, but you have a problem because one of your children has problems with drug addiction, then don't wait and think about, well, I don't know how to deal with it. Just go, because there's lots of good solutions. Lots of the solutions involve trust. So let's talk about the basic components of a trust. If you have children under the age of 18, you can't give them money. And so you're going to say, put it in a trust, use it for their maintenance and education and benefit, hockey fees, ballet fees, all those things that children need under the age of 18. And that money will go to the guardian to help pay for their support. And then if you said nothing more, the children would get the money at 18. Well, not always a good idea to give big lump sums of money to children who are 18, because they like to go have big parties and they like to go to Europe. I would also say that the problem with giving money to children too young is that it attracts a lot of bad friends. So I've observed that when somebody suddenly gets a whole bunch of money in an estate, there's a lot of people who show up to be their friends. And when the money runs out, they're not friends anymore. And so the last thing you want is leaving money to your children that will be a bad news story. You want it to be a good news story. So we usually recommend that with children, that you put it in trust and give it to them in installments. So give them a third at 25, give them another third at 30, and the balance at 35. Nowadays, most children postpone getting married till they're close to 30. They're not having kids, or their kids are just starting to come in the 30 to 35 range. So that's when parents and kids usually need more money. And so it's not a bad idea to postpone it till then. I think making children wait for money can never be a bad thing, especially if in the trust you can say they can get a down payment for a house, they can get their wedding paid for, you can provide for them a lot. But if you give money to kids too early, it can be a bad news story. So we're big on postponing it a bit later. For grandchildren, I'm a big a big believer that it's nice to leave a small gift, a large gift if you like, to grandchildren. I think wills represent relationships. So who are the most special people in your life? Children, grandchildren, maybe it's nieces and nephews, maybe it's your godchildren, maybe it's your next door neighbor. Whoever it is that's special to you, you could leave some money to. If you're going to leave it to young children like grandchildren, it should go in a trust as well. So you can say, put it in trust, use it for their education. When they become 25 or 30, depending on how much money you're leaving them, you can then pay it out to them. Second marriages are often hard to plan for because we love our new spouse. Maybe our children don't, but we do. And we want to provide for them. But we also want to provide for our children from our first marriage because they're important to you as well. And sometimes it's hard to balance those two things. If you have crazy amounts of money, like $10 million, of course you can do it. But if you have a smaller amount of money, it's not always easy to do that. And you can do that by way of setting up a trust for your spouse so they can use money while they're alive and support themselves. And when they die, the balance of that money can go back to your kids from a first marriage. I have pets on here because I've done some seminars for the SPCA. In fact, I'm doing another one later in June. And it is important to provide for your pets. And lots of people have pets that are super important to them. And so you can name a caregiver for your pets, but you can also leave a caregiving fund. You may have remembered a story about Leona Helmsley, who left $12 million to her dog. So perhaps not quite that much, but you could do it by way of a formula that says, leave a fund for my dog based on the average that I spent in the couple of years before I died times the number of expected the life expectancy of my pet. And then the caregiver just gets that amount of money. If you leave a caregiving fund, generally your pet will not be euthanized because the Humane Society or the SPCA will find a home for your pet using that money that you have left for your pet. The question is, does the second spouse automatically take the place of the spouse written in older documents? No, not necessarily. You need to update those documents so that there's no confusion about who you're dealing with. So when you replace your spouse, you should also replace your will or replace her in your will because you don't want to leave that confusion at all. Generally, a will is going to name that spouse, so then you really aren't doing anything. And in the event that you've divorced the spouse, then they would not be entitled to your will. If you're just separated, they may still have an entitlement. So anytime you're changing your status, your relationship status, you should definitely update your will. And we say sooner rather than later. So if you now are in divorce proceedings, you should change your will. You shouldn't wait till the divorce is over. If you reconcile and get back together, you can always change your will back. But we've had people who've died in the middle of a divorce, and the spouse that they were in a supreme battle with gets everything, and that makes families very unhappy. Okay. So carrying on with the basic components of a will, you should definitely deal with personal assets, having a system of who gets jewelry and art. We talked a bit about that. I think in the will, you should say, that that your children can, you might have a list of things and who gets them. And then after that, your children can choose in birth order or reverse birth order how to get them. Or you can say choose, if there's more than one person who wants something, throw their names in a hat. Whatever you think is appropriate, just having a system and telling them how to do it means that then they won't have fights about it. And I've certainly ended up in court over that. Lots of people think that there's putting funeral instructions in a will is a good place to put them, but generally it is not, because usually the call I get is, my dad died 2 weeks ago, now we'd like to come in and look at his will. So if he had instructions in that will about his funeral, they have not been followed. And so generally we would say have a separate letter and tell your executor where the letter is. And the nice thing about the letter is that you can put lots in a letter that you wouldn't necessarily put in a legal document like a will. So you can pick your flowers and your songs and which scotches you want served at the wake afterwards or at the lunch afterwards. And you can change your mind about that as many times as you want without having to change your will. But your will can just say, follow any letter that I leave behind. And I will tell you from a psychological point of view, those letters are very therapeutic for families because they know what you wanted and they feel like they can follow that. On death, there's a very special credit for charitable gifts. So you can leave money to the Alzheimer's Society in your will, and that offsets your taxes. There will be taxes, like we said, on pensions, RSPs, on the sale of your cottage property. If your shares in your investment accounts have gone up in value, all of those things there will be tax on when you die, unless it's going to a spouse, just to be clear. But then when the second spouse dies, then of course there will be that tax. And so with the 100% credit, you can have really the money diverted from Ottawa to charity. And so I highly encourage people to think about giving charitable gifts in your will. It is a time when you no longer need the money. And small gifts don't make a big difference to your beneficiaries, but they make a big difference in terms of offsetting that tax. So don't give gifts when the first spouse dies. You want to give gifts when the second spouse dies, because that's when the bigger taxable gift or the bigger tax effect comes. So in terms of, giving to the Alzheimer's Society, you need to know that close to 50,000 people in Alberta and the Northwest Territories are living with this dementia. The dementia is getting earlier, which is very sad to see. 1 in 11 people under age 65 are diagnosed. And at 85, it's 1 in 2. And so those are things we need to think about. The gift allows the society to provide education and support services, which is so important. And of course, COVID has really decimated all charities, including the Alzheimer's Society, because they have not been able to hold their events. And so they've had a 50% decrease in money coming in the door. And the need for services continues to go up. So lots of ways to donate. Certainly a one-time donation now, a monthly donation. You can make donations in honor of someone. Please consider that, in your letter in your funeral, that you'd like donations to be made to the Alzheimer's Society in lieu of flowers. That's a big part of the giving to the Alzheimer's Society. For sure, leaving a gift in your will of an amount of money can be so helpful. There are special tax rules for giving of stock that has gone up in value. You'll pay no tax on that. So certainly there's people at the Alzheimer's Society that can help you. There's a phone number in terms of helping you to make this gift. But I certainly encourage you to think about charitable giving in your will. And if you've been affected by Alzheimer's, please think about giving something to the Alzheimer's Society. I just wanted to touch quickly on this topic. I know we're running a bit out of time. Please don't hesitate to keep asking questions. But lots of people give money to their children for weddings, for buying a house. And then the question is, so is that money a loan or is it a gift? And the answer I get back is often very uncertain about whether it's a loan or a gift. And the basic message I want to leave you with is, if you loan your children money and you treat it as a promissory note, you actually evidence the fact that it's a loan, you can always gift it to them. You can always say, you don't have to pay me that back. You can, in your will, say, all those loans I made during my life, not have to pay it back. But let's think about this. If you gift your children $50,000 to help them buy a house when they're getting married, and then they get divorced, that $50,000 is now lost in the divorce, because for sure the person who they married will say, oh yeah, that was a gift to both of us. But if you treat it as a loan, then when that divorce happens, you can call the loan. You can say, no, you have to pay me back now. And then the money will come out of the house. And when your child's through the divorce, you can give it to them again to start again to buy a house. So if you think about this, you can always make a loan a gift, but you can't make a gift a loan. You can't turn the gift into a loan, but you can for sure eventually gift the loan. So we've seen lots of situations where parents insert themselves in their child's divorce to try and get gifts back. Those are not very successful. So a little bit of planning where you say, no, we're going to treat these as loans, even if you never plan to collect them, makes a big difference in the event that there's some marriage failure in the family. You need to have good records about how much money went. We recommend a promissory note. Sometimes we actually secure it with a private mortgage on the house. It's very clear that that is not a gift of money. Just quickly, what happens if someone dies without a will? We've talked about who becomes the administrator, but remember that they have to go to court to get that appointment. But then you're considered an intestate. And so generally in Alberta, the rule is that if you have a surviving spouse and children of that relationship, it just all goes to the spouse. If you have children of a different relationship, the spouse will receive the greater of $150,000 or 50% of the estate, and the residue will be divided between the children. If there's no spouse or partner, then it'll just all go to the children. If there's no children, it just keeps going down the line of family members, and it just stops where it finds one. So if there's no parents, no grandparents, but you have brothers and sisters, it just goes to the brothers and sisters. If there's no brothers and sisters, it goes to nieces and nephews. It just stops there. If there's actually no one, no kissing cousin twice removed, it goes to the government. So if we see lots of people who have small families, they don't have children. Those people should do wills as well, because wouldn't it be great if you could use your money for great purposes, great charitable purposes like Alzheimer's programs or the Alzheimer's Society or other charities that are important to you, so that rather than having it just go to the government, unless, of course, the government is your favorite charity. And if someone depends on you and you die without making proper support for them, there is a maintenance and support section under the Act. So for spouses or partners or dependent children, and that's children who are minors or children up to 22 years of age if they're in school full-time, or grandchildren if the grandparent acted as a parent, then under the maintenance enforcement sections of the Wills and Succession Act, they can apply for support. So if you don't provide for these people in your will or don't provide enough for them, then they can make a claim to overturn your will in terms of getting them support. And under the Matrimonial Property Act, a spouse may also have a claim if she didn't receive the whole estate. So I know I went a bit over, so my apologies. But here's my call to action to you, and I'm going to end with a little bit of a story in terms of choosing advisors and avoiding procrastination. I had this woman whose husband went in to have an appendix operation, and she was sitting by his bedside, and the nurses said, "Oh, go home. He's doing so well. It's not like he's going to die or anything." And so she decided to go home, and then she got a call in the middle of the night and said, "Oh my God, he has this terrible infection. You better come." And before she made it back, he had died. So we, of course, never know when our expiry date is. And she, it was a second marriage. The children from the first marriage for the guy who died were terrible. They didn't call their dad. They didn't give him a birthday card. They didn't see him at Christmas. They were completely estranged. But of course, now that he's died, they're going to get a chunk of his farm, which was a very valuable farm. So they were completely interested after he died. And if we had divided the estate the way it was intended under the intestate succession provisions, the wife would not have gotten enough. And so we made a claim to get more of the estate for her. And one day she was in my office when we were going through this litigation, and she said, "Oh, I'm so devastated. This is all my fault." And I thought she was just, grieving. And I said, "Don't worry, we'll get through this. It'll be fine." And she said, "No, this is my fault because I made all of the appointments in my family. I made the appointments to go to the dentist. I made the appointments with the accountant to get the taxes done. And if I had made an appointment with a lawyer to get our wills done, we would have gotten them done. He would have left everything to me, and we would not be in this mess." And I must say, I didn't have much of an answer for her, but I will say that's your little parable for the day. So if you're the person in your family who makes appointments, don't wait for somebody else to do it. Get your appointment made, and then you can get your will done and hopefully avoid lots of the problems that other families have faced by not having them. In this pandemic time, we're seeing people on Zoom or some kind of webinar or by conference call, and the wills are getting signed using social distancing. There are some provisions for video signing, but they aren't very good, so we're not using that very often. And we're actually just encouraging people to call their neighbors over and do it in the garage where there's lots of fresh air and the virus doesn't travel very well, and you can use the car to social distance and use it as your table. Anyway, I hope you have enjoyed tonight, and I just encourage you to get your documents done, and you're welcome to call me or check out your favorite lawyer who does wills and estates. Just going to check and see if there's any other questions. I don't see any right now.
Hi there, Doris. It's Christine again.
Hi.
So you actually have quite a few questions. I was trying to let you get through your slides just so you can get through all the information. So I'm going to do my best because there's quite a few similar ones. So I hope that people feel like they're still getting their answers or their answers to the questions they have asked. But I'm just going to try and summarize for the sake of time at this point.
Perfect.
So the first one that 4 or 5 people have asked or were curious about is, how do we turn on the springing power of attorney?
Usually the power of attorney says how you do it. So normally they say either with 1 or 2 doctor's certificates is how the power of attorney will come into effect. So you're going to follow the power of attorney first if it says how it's to come into effect. If it doesn't, the default in the act is 2 healthcare service providers. So that can be a doctor, a psychologist, a nurse who's trained in the area, who provides certificates to say that the person has lost capacity.
Okay, so the next question, and this might be a part of a larger topic, possibly even a whole separate webinar. We've had quite a few people send in or asking questions about so when and where does medically assisted dying come into effect? Is it included in your in your personal directive? Mm-hmm. Can you make it a request? If you could speak to that a little bit generally, that would be great.
Sure. So medical assistance in dying in Canada right now only is permitted where you have a terminal disease and you have intolerable suffering, and you have the mental capacity to make the decision. We believe that very soon the law will change so that someone's agent can make the decision for them. And there has been a case in BC where someone in the early stages of Alzheimer's was given the permission to have medical assistance in dying. So we're encouraging people to put that in their personal directive if they feel that that's what they would want, for 2 reasons. 1, because we believe the law will catch up and say that agents can make that decision for the person. So we say, in the personal directive, if I have intolerable suffering and I have a terminal disease, I want my agent to consider and potentially consent to medical assistance in dying if they think it's appropriate. The second reason we put that in is because if you felt strongly that you were in a state where you had intolerable suffering, which can be interpreted in many ways, and a terminal disease, then that also shows, and you would have wanted medical assistance in dying, I think that shows that you probably don't want to be hooked up to machines in that circumstance, or you want to be taken off machines in that circumstance. So it helps your agents make the decisions about using or interventions in terms of keeping you alive for a long time. So I encourage people, I ask the question all the time when I'm doing the document, and I encourage people to think about putting it in their personal directive.
Okay, so there's a couple more questions around personal directive in terms of, if you have more than 1 person, do they all have to agree on a medical decision, and what happens if they don't? Really
good question. So if you have more than Two, you can say in your personal directive that they can decide by majority, right? And then, but you need to say that, otherwise it has to be unanimous. So you definitely want to give them that authority that if there's an odd number, they can decide by majority. Well, even if you have an even number, you could have a majority once you're at 4 or 5 or whatever. But then we have a default, and we say if you can't decide by majority, then you should have then the agents or the attorneys under your power of attorney or your executors under your will appoint an arbitrator, and the arbitrator will make the decision. And the reason I really like putting arbitration clauses in all the documents is because, again, it keeps your family out of court. So now you have privacy. It's decided much quicker because you're choosing an arbitrator and you're in a boardroom making that decision. Much less expensive than going to court. So we're very big on putting arbitration clauses in all our documents to make sure that once you've appointed more than one person, you have a way to solve disputes that's cheap and, well, cheaper than going to court, and also private.
Okay. So the next kind of bulk of questions is around green sleeves.
Oh, okay.
And how do those pertain to a personal directive? Or maybe could you speak a little more to those?
Mm-hmm. So just in case you don't know what a green sleeve is, if you've been involved in the healthcare system, then you may be given a green sleeve, which then sets out what your goals of care are. So a healthcare provider would have sat down with you, a nurse or someone, and would have explained various aspects of what kind of care you want. What kind of resuscitation? Do you want resuscitation? They would have gone through all of those goals of care, and you would have figured that out. And then they literally put that document in a plastic sleeve that's green. So that's how they become called green sleeves. And they encourage people to put those on their fridge so that if an ambulance comes, the ambulance can look at your goals of care and know what kind of care you should be getting or not getting. So if you absolutely do not want to be resuscitated, then that's what your green sleeve would say. And the ambulance driver should follow those instructions. They don't always, but they should. So the green sleeve works with your personal directive. It should be similar in terms of your goals of care, but the one thing that's missing in the green sleeve is that it doesn't have an appointment of an agent. And that's what the personal directive does. So you still need both documents. You can't just have a green sleeve. But you could, in your personal directive, say, I appoint Sally as my agent, and I want her to follow the instructions I have in my green sleeve. That would be perfect. But you can't have just a green sleeve.
Okay. I'm just going to do a couple more questions, and then I think we'll wrap up tonight's presentation. There's been a couple of people who have asked, in terms of a personal directive or appointing someone, if you don't have anyone, what's the procedure? Or if you do have someone, is it possible to challenge that?
Let me start with the latter part. So let's say someone's been appointed and the family doesn't think that's a good choice. So maybe they've appointed, their latest girlfriend or somebody who was a caregiver who suddenly now has a much bigger role. They're hard to challenge. If the person had capacity when they signed their personal directive, courts like to uphold those wishes. And so they're pretty hard to challenge. I don't know if the question was more, if I did one and now I'd like to challenge my own, can I do that? You can, as long as you have capacity. And so I sometimes get that call where the person's saying, I don't like the decisions the person is making for me. And I say, we can certainly challenge it. You need to go to a doctor and get a certificate of capacity that you can make your own decisions. And then we can absolutely challenge it. Or we could just do a new personal directive. If you have capacity, you can do a new personal directive and revoke the first one. And now you have someone in place. So I'm pretty sure I answered the second part of the question, but I can't remember, Christine, what the first part was.
Oh, okay, no problem. So if a person does not have a family or a friend that can be an agent, who then would a personal directive name? Would it be a public guardian?
You can name the public guardian's office, but you need their permission first. That's not exactly the first choice, of course, because then you're basically appointing the government to make decisions for you about your health care. And they kind of have policies and make the same decisions for everyone. If you really, hopefully you can dig deep and find a good friend or find someone who can be your agent to make healthcare decisions. If not, it would be the public guardian's office.
Okay. This question's around estate. So if a couple was married and have been separated for years with no communication, does the spouse still have legal right to the estate?
So it depends what we're exactly talking about, but in terms of if there's no will, do they get it pursuant to an intestacy? If the separation's been longer than 2 years, the answer is no. Although, there's an asterisk around that in terms of what was the reason for the separation. We had a case where the woman left because her husband was absolutely abusive and had serious mental illness. So she didn't leave voluntarily. So we suggested that she should still get the estate, and she did. But generally, if they've been separated for 2 years or more, they would not get the estate. But they might still, if there's been no divorce, have the right to apply for support under the maintenance and sections of the Wills and Succession Act. So separations are complicated. So when we see a separation, we say, if you're never getting back together, you should just finalize that divorce, because that separation makes your estate very complicated.
Okay, and finally, someone just asked, how much should things like this cost in terms of seeing a lawyer or getting these documents completed?
So I would say that we usually do the package for a couple. So the will, enduring power of attorney, personal directive, and the package is around $950 to $1,200. If you're going to have really complicated trusts, it would be more expensive. But generally, that's around the cost for the package for a couple, and for an individual, it would be $750.
Okay, well, thank you very much again, Doris.
Oh, you're very welcome.
Excellent.
Thanks for having
information. Me. Yes, absolutely. And just to let everyone know that this was recorded and will be edited and archived on our Assant Cafe if people would like to rewatch. And thank you again so much for your time tonight, Doris. Really appreciate it.
Thanks for everyone joining us. That's so great. I love talking about this topic, and I'm so happy when people come and listen. So thank you very much.
Great. Okay, everyone, thanks and have a good evening.